Did you know that 98% of all federal criminal cases end with the defendant being convicted and sentenced by a judge? This staggering statistic is the unfortunate reality that individuals charged in federal court find themselves in. Because of that sad fact, federal criminal defense lawyers must be well versed in the rules and procedures that govern federal sentencing. In this video, I'll go over a brief overview of how the federal sentencing guidelines work when someone is convicted of a federal offense. My name is Joseph Scrofano, and I'm the founder of Scrofano Law PC, a criminal defense firm that represents individuals under investigation or charged with a crime in the District of Columbia, Maryland, and Virginia. The federal sentencing guidelines are rules that federal judges are required to consider when sentencing someone who's been convicted of a federal crime. For many years, the guidelines were mandatory and had to be followed by the judge without any exercise of discretion. The sentencing guidelines are extremely complicated, and the manual itself is 608 pages long. But here is a brief overview of the guidelines, which are now voluntary. The guidelines assign most federal crimes an offense level between 1 and 43. The more severe the crime, the higher the offense level. An individual offender is also assigned to one of 6 criminal history categories based upon the extent of their past criminal activity. Together, these two numbers produce a sentencing range, a range of months that the judge is advised to sentence a particular defendant to prison for. That may seem pretty simple, but there's a lot more to it. Determining the offense level is not at all straightforward in a federal criminal case. As I mentioned, the sentencing guidelines provide 43 levels of offenses based on seriousness. Each offense is assigned a base offense level. First-degree murder has a base offense level of 43. Kidnapping has a base offense level of 32. But the base level is just the starting point. To get to the final base level, you have to add or subtract any specific offense characteristics and general adjustments that may apply. Yes, it's complicated and can be very confusing to someone accused of a federal crime or really even for an attorney. The way it works is, imagine a chart or a graph where the y-axis is the offense level and the x-axis is the individual's criminal history score. Where the individual falls on these two axes determines what their sentencing guideline range is. For instance, the offense level for a residential burglary begins at 17 and may go up based on how much property was stolen. If the burglary resulted in a loss of more than $5,000, one level is added. But for a loss of more than $1.5 million, 5 levels are added. Robbery has a base level of 20, but if the offender brandished a firearm during the robbery, a 5-level increase applies. For drug distribution cases, it's the quantity of drugs that drive the guideline calculations. But those calculations will also be affected by many other factors, including whether a death or serious bodily injury resulted from the use of the drugs, whether a firearm was possessed by the defendant, or there was any act of violence associated with the crime. For fraud or theft cases, the guidelines are dramatically affected by the amount of loss to the victim. For instance, a $15,000 loss amount will add 4 points to a defendant's guidelines, while a $250,000 loss amount will add 12 points. As the loss amount increases, so will the length of the recommended prison sentence. Guideline adjustments are factors that can apply to any offense and increase or decrease the offense level. They are categorized as victim-related adjustments, the offender's role in the offense, obstruction of justice, multiple counts, and acceptance of responsibility. For instance, if the crime was motivated by hate, the offense level increases by 3 levels. If the offender was a minimal participant in the offense level decreases by 4 levels. If the offender knew that the victim was unusually vulnerable due to age or physical or mental condition, the offense level is increased by 2 levels. If the offender obstructed justice, the offense level goes up 2 levels. If the offender clearly accepts responsibility, the offense level goes down 2 levels. As complicated as the sentencing guidelines are, a judge cannot simply follow them blindly. There are other factors that a judge must consider when formulating her sentence. These factors are referred to as the Booker factors. They are supposed to guide the judge in crafting a sentence that is sufficient, but not greater than necessary to accomplish the goals of sentencing. These include the circumstances and nature of the particular offense, the specific defendant's personal characteristics and history, the necessity of avoiding unwarranted differences amongst sentences, the societal need for the sentence imposed, which basically means that it should meet the goal of deterring future lawbreakers, promoting respect for law, providing an appropriate punishment, and providing rehabilitation. In my experience, the fact that judges can depart from guidelines is usually beneficial to defendants. In almost every federal sentencing I've done, I've requested a sentence that falls under the guidelines and have had success in getting a judge to agree and depart or vary. Judges who seriously consider the non-guideline factors often come to the conclusion that the guideline range is simply too high. These guidelines often produce draconian sentencing results that in most cases in federal court make the risk of losing at trial too great for the accused. Accordingly, it's no surprise that over 90% of all federal criminal cases result in plea agreements. Because so many federal cases result in plea agreements and sentencing, federal criminal defense lawyers must spend a lot of time and energy on the sentencing process. This includes accurately calculating the sentencing guideline range, obtaining character letters from members of the community in support of family members, preparing a lengthy sentencing memorandum for the judge, and preparing a compelling sentencing argument that addresses all of the factors that the judge must consider. An important part is humanizing the client. A sentencing presentation in federal court tends to be much more involved than one in local or state court. The stakes are often much higher, and the potential for substantial jail time, even for a first offender in a federal case, is extraordinarily high. Accordingly, if you know someone or are yourself accused or under investigation of a federal crime, contact us today for a full consultation. And for those of you who are interested in learning more about criminal law, don't forget to like this video and subscribe to our channel for all things criminal law.